So I got a foreclosure question. It says, will filing bankruptcy stop foreclosure? And it came from a young lady named Camille. And the answer is yes, maybe. It depends. And let me tell you why. What is foreclosure? Foreclosure is a breach of contract suit. Simple as that. What's saying is that what the foreclosure lawsuit is saying is that you had, Mr. Homeowner, you had made an agreement. You put your home up for collateral to pay this debt. If you don't pay the debt, then we're going to take the collateral back and we're going to sell it and try to recoup some of the money that you had agreed to pay. It's a breach of contract action. Bankruptcy will stop. When you file a bankruptcy, an automatic stay goes into place to prevent creditors from taking certain actions to try to collect on a debt. So, does it stop a foreclosure action? The answer is yes. Now, how long does it stop it for? That's a good question. In a Chapter 7 case, the rules are different than in a Chapter 13. So in a Chapter 7 case, it stops the foreclosure. The debtor, meaning the homeowner, has to tell the creditor what its intentions are. When it files bankruptcy, a Chapter 7 debtor has to have what's called a statement of intention that's filed with the bankruptcy court. In that statement of intention, you're going to tell the creditor exactly what you intend to do. Do you want to reaffirm the debt? Do you want to surrender it? I mean, it's collateral. What are you going to do? Sometimes people surrender their house, and then the bank comes back after the bankruptcy is over and says, hey, let's work it out. Other people say, hey, I want to keep this house. I want to keep paying for it. I need to work out a modification. No problem. But it will stop the foreclosure. Now let's say the bank says, well, I want to keep going with my foreclosure. In a Chapter 7, they have to file a motion for relief from stay if they want quick relief from the court and say, Judge, we want to go litigate this matter and continue to take our collateral. Or the creditor can wait until the Chapter 7 debtor gets their discharge. When the Chapter 7 debtor gets their discharge, then the automatic stay is terminated. And the creditor can pursue what's called an in rem judgment against the property, but it can't come after the individual for what's called an in personam judgment, meaning a money judgment. Think about it. In a Chapter 7, the creditor can pursue its collateral, but it cannot pursue a money judgment because the debt is included in the discharge. When that debtor gets its discharge, the debt's gone. So they can only pursue their collateral. That's called an in rem proceeding. Fancy terminology, all it means is that the bank is going after the property, not after the individual. Chapter 13 is a little bit different. In a Chapter 13, the debtor is filing a plan. In that plan, they can pay the creditor directly, which means that the automatic stay disappears. But if they start paying that creditor and they're behind on the mortgage, they have to pay through the Chapter 13 plan. So each month they have to pay a monthly payment. They have to pay a portion of the arrears, the trustee's fees, to go along and reorganize under Chapter 13. Number 2, the debtor can surrender the property in Chapter 13. If the plan says that the debtor is going to surrender the house in foreclosure, then we have a first day order that says the automatic stay terminates because there's no reason to come to court and ask for permission to go take the house when the debtor's agreeing to it, saying, I'm going to give this house back anyway. Then the property goes back the case goes back to state court immediately, and they go ahead and they continue with the foreclosure. Alternatively, there's something that's what's called mediation. You can request, well, in the Middle District, Southwest Florida region, you can go ahead and request the court to go to mediation. At that point in time, you can pay an adequate protection payment, meaning some monetary payment, to the creditor through the plan and ask to go to mediation to try to work out a deal with your creditor. If you can work out a deal with your creditor and modify the plan, then whatever that modification includes, you amend your plan, file a new plan with the court telling all the creditors all the details of what's going on, and this way you can go ahead under the new operation. As long as the trustee understands what's going on, I don't think it'll be a problem. The court sanctioning mediation, saying that they want creditors, or meaning mortgage creditors and debtors, to work out their differences and keep people in their homes, reorganize the other debt, and it actually makes sense. So bankruptcy will stop foreclosure in some circumstances. In other circumstances where the person is saying, hey, I don't want the house anyway, it won't stop it permanently, but it may stop it temporarily depending on what's going on. And hopefully I explained that a little bit. If I didn't, please send us questions at dulutrilawgroup.com, and I'll be more than happy to try to follow up on a different show about what I said and try to make it a little bit more clearer for those who didn't understand.